Hello everyone. YuktMind is ready with its initiative 10 minutes and newspaper done, where we offer concrete, crisp and quality content to help you sail the ship of this UPSC journey. Today is 26th May and only 7 articles have been selected of your relevance. You can download the PDF of the gist from our Telegram channel or website Daily Current Affairs tab. First news, all-in-one policy plan to spread insurance in India. If India's insurance regulators' plans fructify, households across the country could soon be able to get an affordable single policy that covers health, life, property, accident, etc., and even secure value-added services such as gym, yoga membership at the time of buying a policy. The insurance regulator, Insurance Regulatory and Development Authority of India, is working on a three-pronged approach: availability, accessibility and affordability to ensure insurance for all by 2047 with a Gram Panchayat to district to state level approach. This is being proposed through Bima Trinity, Bima Sugam, Bima Vistar and the women-centric Bima Vahak. Now what is IRDAI? It is a statutory body under the jurisdiction of Ministry of Finance, Government of India, formed under the Act of Parliament, IRDAI Act of 1999. It supervises and regulates the insurance sector in India. It is a 10-member body with a chairman, 5 full-time members and 4 part-time members. IRDAI is moving from a rule-based approach to a principle-based approach, that the opportunity to invest in the insurance sector is immense given the size of the market and that India's insurance penetration is very low. Economic Survey 22-23 also noted the growth of the insurance sector to be slow and said it needs to be faster. Insurance penetration was 2.7% in 2000 and it is only 4.2% in 2021. You can find these details and write up in PDF provided in Telegram channel. As many as 70 odd regulations have been repealed, 1,000 odd circulars have done away with, and 79 returns rationalized. IRDAI is striving to create an UPI-like movement in insurance through a plan worked out with general and life insurance firms. Let's talk about Bima Trinity. A new Bima Sugam platform will integrate insurers and distributors onto one platform to make it a one-stop shop for customers who at a later stage can pursue service requests and settlement of claims through the same portal. Bima Vistar, that will be bundled risk cover for life, health, property and casualties or accidents with defined benefits for each risk that can be paid out faster than usual without the need for surveyors. The third party of the Trinity envisaged by the IRDAI entails a women-centric workforce of Bima Vahaks in each Gram Sabha that will meet the women heads of each household to convince them that a composite insurance product like Bima Vistar can come in handy if there is any distress. Now, IRDAI is taking several initiatives. Like recently, they asked general insurers to talk to transport authorities of 28 states and 8 UTs to provide mandatory covers for the uninsured vehicles. They have come up with a zero tolerance policy to achieve 100% motor insurance. You can find this right up in the PDF. Second news, China constructing model villages opposite the LAC. Now, what is LAC? Line of actual control is a demarcation that separates Indian controlled territory from Chinese controlled territory. The 3,488-kilometer long LAC is divided into 3 parts: western, middle and eastern sectors. Since the beginning of the standoff with China in eastern Ladakh in April 2020, there has been build-up of forces by the People's Liberation Army and transgressions in other areas along the LAC. China is continuing to expand the network of model villages or Shiokang villages opposite the line of actual control in the middle and eastern sectors, that is Himachal Pradesh, Sikkim and Arunachal Pradesh. While China continues to expand infrastructure, India too has almost reached parity in terms of roads and other infrastructure in the middle sector. There also has been major induction of new technology by the Indian Army along the LAC. Like new autonomous vehicles will soon replace animal transport for transporting rations and utilities to soldiers in forward locations. Snow scooters, laser dazzlers and new generation snipers have also been inducted. Now, note that LAC is not agreed by the two countries and is only a concept. Now, how was LAC evolved? Listen to me carefully. The line which delineates the boundary between the two countries is popularly called the McMahon Line, after its author Sir Henry McMahon. Then comes 1913, British India government had called a tripartite conference with Tibet, which led to the convention and delimitation of the Indo-Tibetan boundary. But this is disputed by China, and China terms it illegal. Now comes 1957, post-independent, China occupied Aksai Chin, built a road through it, which led to 1962 war. Post this, a military-held line boundary came into existence known as LAC. Third news, following the death of three cheetah cubs this week, the center appointed a new steering committee comprising national and international experts to oversee the implementation of Project Cheetah. The cubs were born to a translocated Namibian cheetah at the Kuno National Park in Madhya Pradesh in March 2023. The committee's mandate is to monitor the progress of the cheetah reintroduction program and advise the Madhya Pradesh Forest Department and the National Tiger Conservation Authority. Now, these are the African cheetahs which were brought from Namibia, and they are listed as vulnerable in the IUCN Red List. Asiatic cheetahs, which have a very small population base in Iran and were present in India before independence, are listed as critically endangered species in IUCN Red List of threatened species. Fourth news is about recusal of judges. Last week, former Supreme Court Judge Justice M.R. Shah refused to recuse himself from hearing a play by former IPS officer Sanjeev Bhatt to submit additional evidence to back his Gujarat High Court appeal against his conviction in a 1990 custodial death case. Similarly, a few weeks ago, the Chief Justice of India, D.Y. Chandrachud, rejected an application seeking his recusal from hearing petitions seeking legal recognition of same-sex marriages. Now, why do judges recuse? Whenever there is a potential conflict of interest, a judge can withdraw from a case to prevent the perception that the judge was biased while deciding a case. This conflict of interest can arise in many ways, from holding shares in a litigant company to having a prior or personal association with a party. Another common reason is when an appeal is filed in the Supreme Court against a High Court judgment delivered by the concerned judge before his elevation from the High Court to the Supreme Court. The practice stems from the cardinal principle of due process of law that no person shall be a judge in his own case. Another principle guiding judicial recusal is justice may not only be done but must also be seen to be done, propounded in 1924 in Rex v. Sussex Justices by the then Lord Chief Justice of England. By taking the oath of office, judges promise to perform their duties without fear or favor, affection or ill will, in accordance with the third schedule of the Constitution. There are two kinds of recusals: an automatic recusal where a judge himself withdraws from the case, or when a party raises a plea for recusal. The decision to recuse rests solely on the conscience and discretion of the judge, and no party can compel a judge to withdraw from a case. India has no codified rules governing recusals, although several Supreme Court judgments have dealt with the issue. Since there are no statutory rules governing the process, it is often left to the judges themselves to record reasons for recusals. The Delhi High Court recently ruled that no litigant or third party has any right to intervene, comment, or inquire regarding a judge's recusal from a case. Now, what rules has the Supreme Court formulated in the past? The Supreme Court has over time outlined various factors to be taken into consideration for deciding the impartiality of a judge. In Ranjit Thakur versus Union of India case, the Supreme Court held that to determine if a judge should recuse, what is relevant is the reasonableness of the apprehension of bias in the mind of the concerned party. The Supreme Court in State of West Bengal versus Shivnanda Pathak defined judicial bias as a preconceived opinion or a predisposition or a predetermination to decide a case or an issue in a particular manner, so much so that such predisposition does not leave the mind open to conviction. Formulating a more definite rule in the Supreme Court advocates on record association versus the Union of India, the court observed that where a judge has a pecuniary interest, no further inquiry is needed as to whether there was a real danger or reasonable suspicion of bias. Now let's talk about foreign jurisdictions on recusal. Contrast with India, the USA has a well-defined law on recusals. This specifies three grounds for recusal: financial or corporate interest, a case in which the judge was material witness or a lawyer, and a relationship to a party. However, on several occasions, judges recuse on their own. known as sua sponte recusals. The UK's law on judicial recusals evolved through judicial pronouncements. In the landmark case of R versus Gog, the real danger test was adopted as the applicable standard based on which recusal orders need to be passed, which was based on substantive and tangible evidence. A new test was formulated in Lowell versus Northern Spirit Limited, but the standard laid down was to look at the likelihood of bias from the perspective of a fair-minded and a responsible observer. Fifth news is about various articles of Constitution associated with Delhi Services issue. Article 123 is power of President to promulgate ordinances during recess of Parliament. If at any time, except when both houses of Parliament are in session, the President is satisfied that circumstances exist which render it necessary for him to take immediate action, he may promulgate such ordinance as the circumstances appear to him. An ordinance promulgated under this article shall have the same force and effect as an act of Parliament. But remember that it shall cease to operate at the expiration of 6 weeks from the reassemble of Parliament. If and so far as an ordinance under this article makes any provision which Parliament would not under this Constitution be competent to enact, it shall be void. That means power of Parliament and ordinance is same and they cannot change the basic structure of the Constitution. Now, question of judicial review under Article 123. In the landmark 7-judge bench verdict of the Supreme Court in the matter of Krishna Kumar Singh versus State of Bihar, the court held that the satisfaction of the precedent under Article 123 is not immune from judicial scrutiny. The powers under Article 123 is not a parallel source of lawmaking or an independent legislative authority. That means it can only be done during emergency and it cannot be an alternative to Parliament. After Article 123, let's discuss other articles related to Delhi Services issue. Article 137, review of judgments or orders by the Supreme Court subject to the provisions of any law made by Parliament or any rules made under Article 145. The Supreme Court shall have power to review any judgment pronounced or order made by it. When a constitution bench of the Supreme Court declares the law, the same is binding on all courts and authorities in India in terms of Article 141 and 144. Now, what is Article 141? That is, the law declared by the Supreme Court shall be binding on all courts within the territory of India. What is Article 144? All authorities, civil and judicial, in the territory of India shall act in aid of the Supreme Court. The powers to amend the Constitution is given under Article 368. Parliament may, in exercise of its constituent power, amend by way of addition, variation, or repeal any provision of this Constitution in accordance with the procedure laid down in this article. It is done under a special majority as mentioned in the clause 2. If the part of the Constitution which is supposed to be amended is of federal nature, that is, it involves states, the amendment shall also require to be ratified by the legislature of not less than one half of the states by resolution to that effect passed by those legislature before the bill making provision for such amendment is presented to the President for assent. Clause 5 of the article reads that it is hereby declared that there shall be no limitation whatever on the constituent power of Parliament to amend by way of addition, variation, or repeal of this Constitution under this article. But in 1973 case of Nanda Bharti case, Supreme Court restricted it through basic structure doctrine. Sixth news, Chinese hackers attacking infrastructure warns USA. According to Microsoft, state-sponsored Chinese hackers have infiltrated critical US infrastructure networks, Washington, its Western allies, and while warning that similar espionage attacks could be occurring globally. Seventh news is about CBI. CBI is the premier investigating police agency in India. It provides assistance to the Central Vigilance Commission and Lokpal. It functions under the superintendence of the Department of Personnel, Ministry of Personal Pension and Public Grievances, Government of India, which falls under the Prime Minister's office. However, for investigation of offences under the Prevention of Corruption Act, its superintendence vests with the Central Vigilance Commission. It is also the nodal police agency in India which coordinates investigation on behalf of Interpol member countries. In 1963, the CBI was established by the Government of India with a view to investigate serious crimes related to defense of India, corruption in high places, serious fraud, cheating and embezzlement, and social crime. particularly of hoarding, black marketing, profiteering in essential commodities, having all India and interstate ramifications. The CBI is not a statutory body but derives its power to investigate from the Delhi Special Police Establishment Act 1946. The establishment of the CBI was recommended by Sandanam Committee on Prevention of Corruption 1962 to 64. Thank you for watching. Let us know your feedback in the comments. Keep visiting our website, Telegram, Instagram, and Twitter.